There's a huge number of you on today's webinar. So we promised to one another that we will not appear outwardly nervous, but we are. We realize this is incredibly important, and a lot of you have dialed into this. And you're right, this is huge. You know, you can look at the title, The Seismic Shift of Schrems II. It's not just alliteration, it's true. This is a very big deal, and it's incredibly problematic. But one thing that we're all committed to by the end of this webinar and throughout, in fact, is to not only outline the problems, but to present you with some options, right? For some of these options will actually be solutions. For others, these will be risk-based options to help you sort of mitigate the risk while still continuing to do business. Because for a lot of people to suddenly say, hey, you can't bring data from the European Union to the United States, even data of wholly US persons, right? Even data of wholly US persons sent to the EU or the UK, even that is impacted by this decision. So we want to make sure that we give you both tactical as well as strategic advice on what you can do. And before I introduce myself and our more impressive panel that we have with us today, I want to make that last point. It's going to be both tactical and strategic. And what's really, really important about Schrems II is no matter how profound it is, this won't be the last you hear. Whether in the EU or the US or in China or Russia, these type of events are going to keep happening. So it's important to take that step back and to seize this opportunity to sort of either generate or refine a more holistic and comprehensive and forward-looking digital strategy. One that may need to incorporate elements of data localization, right? Because we're seeing this in the EU. China has a data localization law. Russia has a data localization law. Even the United States, right? As of this past month of August, President Trump issued an executive order directed at WeChat and limiting the use of WeChat for anyone that comes in the jurisdiction of the United States. And one of the stated reasons for that is because of the personal data flows from the United States to China. So this is going to keep happening. But with that, let me introduce our esteemed panel. I'll first turn it over to my fellow co-lead, Paula Barrett. Paula?
Thanks, Michael. So hi, everybody. I'm Paula Barrett. I have the pleasure of being the global co-lead along with Michael for the data privacy and cybersecurity practice. And looking forward to sharing some more details shortly about this case. Marie.
Thanks, Paula. My name is Marie McGinley. I head up the IP Tech and Data Protection team here in the Dublin office of Evershed Sutherland. Niels.
Thanks, Marie. Yeah, my name is Niels. I'm located here in Munich, Germany, and also happy to be part of this wonderful practice group here and to give you some insights in the crazy data protection world here in Germany.
Robert?
Thanks, Michael. Niels. My name is Robert Santifort. I'm a senior associate in the Dutch Cybersecurity and Privacy Team. Happy to be here today and looking forward to our conversation. Guess you, Michael, to take it off.
Yes, thank you. And this is a brief overview of our agenda, right? We'll start with a basic overview of the Schrems II judgment to make sure everyone is on the same page. And then we're going to spend a good amount of time talking about who is implicated and how the ruling impacts companies. And we're going to do that on a very sort of member state by the United Kingdom position on it all. And then we'll come back and really hit on those key takeaways. So Paula, let's turn this over to you to tell us all the good news about Schrems II, the sequel.
Very happy to. So what has happened? So this is, as a case goes, it's one of those interesting ones where it's sort of knowledge of it is gradually sort of rippled out. It started life in Ireland, and we will be nice to Marie, notwithstanding that during this session. But we'll certainly be coming back to Marie for a view in terms of, in particular, the what's being said on the ground in Ireland. But not surprisingly, perhaps, this case started out in Ireland. In essence, following a series of cases, and you can trace the history of this indeed back to Snowden revelations. But in essence, you may recall back in.
That was my fault, Paula. You started blaming Marie, and now you're.
Sorry. So in essence, we've got this case, a whole history of cases and issues that have arisen. And this is something that has its bedrock in some interesting geopolitical backdrops, which is one of the reasons I refer to Snowden. But this particular case was brought, in essence, by Max Schrems, in essence saying that concerns about the transfer of data to the US in relation to, in this particular case, Facebook and the use of that particular platform. Now, this comes off the back of a case also decision back in 2016, where on a similar basis, case brought again complaining about the use in that particular instance of the safe harbor mechanism to protect data being transferred from Europe to the US. But in this particular instance, the transfer mechanism that was the subject matter was standard contractual clauses. Now, why are these clauses relevant? Well, in essence, you may be aware under the GDPR and indeed, frankly, under previous legislation in Europe, transfers of personal data from Europe to jurisdictions outside of Europe, which don't have an adequacy determination, are seen to be restricted, and you can only make those transfers then if either a derogation applies or an approved mechanism is in place. So one of those mechanisms was safe harbor. Well, that was found to be invalid back in 2016, and in its place, subsequently, a framework was agreed between the US and the EU. In this particular case, Privacy Shield. There was also a mechanism which goes back several years, which is standard contractual clauses. And these are, in essence, template clauses as a controller version, as a processor version. And it's probably the most popular mechanism for dealing with transfers, right? From the EU over to jurisdictions outside of the EU. Whether it's the US, it's the Middle East, it's China. It's used as the most frequently used version because it has historically been something that would be, you put it up, you complete the schedules to it, you sign it, it's done. At least that was perceived wisdom, perhaps. So a popular mechanism, but one that there were some concerns about in the wake of this decision in relation to Privacy Shield and continued concerns about that and how ultimately it would be equally a problem in relation to standard contractual clauses. So case brought in Ireland, it could have been brought against a number of the different commissioners. It was simply that ultimately the Irish commissioner is the lead authority for Facebook and indeed a large number of technology vendors. So case brought in Ireland, Irish commissioner looked at the case and said, you might kind of have a point. And so began a chain of escalation all the way up through the Irish High Court system into the European courts. And this case, some twists and turns, shall we say, ultimately, which ultimately resulted in the decision on the 16th of July. So the case was very much focused originally on standard contractual clauses. And then kind of at the 11th hour, the Privacy Shield got brought within its scope and brought together. And what we ended up with to a degree, to a surprise, was a decision that said that transfers from the EU to the US on the basis of the Privacy Shield were not valid. In essence, or rather the Privacy Shield mechanism was not a valid mechanism for protecting data transferred out of Europe to the US. So Privacy Shield fell, as did its predecessor, Safe Harbor. Now, the interesting point from that is the rationale then that was given in the case as to why. And we'll come on and explore some of the detail of surveillance laws in the US with Michael's help shortly. But ultimately, the concern was that the scope of surveillance laws were such that in essence they would override the Safe Harbor, sorry, the Privacy Shield mechanism, and it did not afford appropriate protection. However, as I said at the beginning, this was a case about standard contractual clauses. So what they went on to say was that standard contractual clauses remained a valid mechanism for dealing with transfers from the EU to jurisdictions outside of the EU. Great. However, and there was a however, because the however was that it was then confirmed it was important for the controllers concerned who were relying on those mechanisms, or indeed the processes, to actually look at whether or not those clauses did in fact provide appropriate safeguards. So the important point was that they have to then look at not just the wording of those contracts, but can the recipient actually comply with it? And to do that, they needed to undertake due diligence about the laws prevailing in the jurisdiction of the data importer. So that means looking at, if it is a transfer to the US surveillance laws. So with that, there was quite a sharp intake of breath as people started to digest the impact, because in the immediacy of the decision, there were then some quite interesting statements that came out from different regulators, and we'll explore some of those in a moment. But there was an initial shockwave, because I think there was a sort of, oh my, what does this mean? Does this mean all bets are off? Hang on, but they've said standard contractual clauses are valid still. What does this really mean? Does this mean we can't transfer to the States anymore on standard contractual clauses? So there's an awful lot of misunderstanding, and I think some as we'll explore, as I said in a moment, some statements that were coming out of different regulators that were not necessarily consistent, and we saw quite a breadth of statements from some that were very hawkish and saying that means no more transfers effectively, through to others saying, well, that's interesting, it casts a serious shadow, through to others just saying, hang fire, we'll come back to you almost. So that was the case. If we move on to the next slide, let's have a look at some of the ruling's impacts in a little bit more detail. As I said, it started out with a decision that Privacy Shield was not a valid mechanism for providing appropriate safeguards. So Privacy Shield has gone. It is, certainly from the date of the decision at least, it is not a valid mechanism. Now there's some debate about whether it wasn't a valid mechanism at all, but if we focus on the case, Privacy Shield has gone. So that meant some approximately 5,300 companies relying on Privacy Shield are left trying to consider other options, because they can't rely on it to go from the EU to the US. I'll pause for a moment, because ultimately there is also a Swiss mechanism that does remain in place at this point in time. But the US-EU Privacy Shield has gone. So that then leaves you with some other options. Now, what are the other options? Well, we have binding corporate rules as well as standard contractual clauses. Both of those exist under the same limb of the GDPR. Both are basically contractual mechanisms, ultimately. And so both have similar considerations now to be applied to them. So if you are relying on these contractual mechanisms, whether it's binding corporate rules or standard contractual clauses, you do need to consider the ability of the recipients of the data under those mechanisms to be able to comply with the contract, or whether the laws in the jurisdiction that they're in are such that they can be overridden through surveillance or other laws, and inappropriate or other access gained to that data by third parties. All of this, of course, means that if you are a global company, you're sort of sat there thinking, okay, so I've gone through the whole mechanism, probably with GDPR, to get some data processing agreements in place, to choose standard contractual clauses or privacy shield or binding corporate rules. Now what do I do? So what we're going to explore as we go through the rest of this session is actually what do you do and what companies are starting to do. I think in part what we also would encourage you to do is to, if you move on to the next slide, please, is to think about this as in a couple of tiers, really, because when you're looking at the transfers, one of the key aspects of this is to think about not only the transfers that might be happening almost at face value, so the transfer that happens, for example, in an intra-group scenario between one company and another, but also whether there is any underlying technology or other services which facilitate that transfer happening as well. And it's important to think about those initial transfers and whether there are indeed technology platforms underpinning those transfers, and indeed onward transfers as well. So it's a sort of multi-layered piece that needs to be worked through. But before we go into some of the details about how you go about approaching the analysis of Schrems and actually then applying that to your particular scenarios and the due diligence exercise, and what does that look like, I think it's perhaps worth just exploring some of the reactions that we have seen from different regulators. Now, there's no accident that we've actually selected Niels, Marie and Robert, as well as obviously Michael as well, to join in relation to this conversation. Not least because I think for a lot of the organizations on this webinar, many of you will have your European, if not your EMEA headquarters very often in these key jurisdictions. So they're very important on that basis, or you may indeed just have a large presence in that jurisdiction. So hence why we thought it was important that you were able to hear what's happening on the ground in those jurisdictions. And then of course, Michael, very much keen to hear more from Michael in terms of actual consideration of US surveillance laws. Now, I'd like to emphasize this is not just about transfers to the US. Yes, that's what the case was looking at, but the impact of this is for transfers to jurisdictions outside of the EU. So whether you're looking west, whether you're looking east, it's anywhere outside of the EEA that you need to be thinking about this, if there isn't already an adequacy decision for that particular jurisdiction. So a transfer to Japan, one of the most recent recipients of an adequacy decision, that's still covered by that adequacy decision. It's other jurisdictions. So whether you're moving to Hong Kong or China or India, for example, then those are the sorts of jurisdictions you'll need to think about. Michael, did you want to just comment in relation to some of the specifics of the case around transfers to the US under applicable surveillance laws? Because I think that's something which has caused a lot of confusion as to the breadth of application.
Yeah, so now we get to take a brief pause into potentially some good news, right? When the case was, brought, and if you read the decision, they're concerned about particular U.S. surveillance authorities, in particular FISA, which is the Foreign Intelligence Surveillance Act, and even more particularly FISA Section 702, FISA 702, which concerns, content collection. So either the substance of telephone calls or, the body of an email, that's the content of non-US persons located abroad. So of course, that was a bit of a thumb in the eye of European regulators to see that there are no protections for people who don't fall into that category, namely European data subjects. But FISA 702 only applies to electronics communications service providers, right? So if you're an industrial company, if you're a financial services company, FISA 702 likely does not apply. However, you also have to take that second step and say, okay, but how exactly is my data flowing from the EU or UK to the United States? Or where exactly am I storing my data? Because if I'm storing it in a cloud, in a public cloud, that could fall under FISA, right? If you're going on a commercial-based email, it could come in under FISA. So important to take a look, not only at who you are, but who your service providers are, and to really break it down by particular data flow. The other authority that they talked about was EO 12333, or Executive Order 12333, which is essentially a presidential directive that dates back decades that talks about US surveillance priorities and sort of authorities for collection outside the United States. The reason FISA came about, 702 in particular, was because that data was suddenly beginning to touch the United States. And then, of course, the US Constitution began to apply to that data. So you had to put in an additional level of protection. But without getting too into it, and there are some certain ironies in this case, I think the bottom line for this conversation is the court was concerned with passive collection along undersea cables, right? Should the US have this capability to tap undersea cables? Will all that data flowing from the EU to the United States get siphoned off to US intelligence community? In that respect, I think we'll talk about, while that will apply all over the place, and again, I'm not taking a view on whether the US can or does do that, but if such passive collection is possible, is there a way to protect that data, for example, through strong encryption? So those were the two authorities that the court focused on. And so, of course, that's going to lead to some of that due diligence Paula was talking about to do the analysis. Hey, does FISA apply? Or do we have sufficient protections when the data transit in cases of passive collection under EO 12333? Paula?
Hi. So that's, it's particularly important, I think, to understand that so that you can then start to apply that to your thinking about how you tackle this particular issue. I'm going to go now, I think, to Marie, because obviously at this particular juncture, the Irish Data Protection Commission is kind of in the hot seat. As the decision obviously has gone back now to her office for consideration in the particular case that triggered all of this. Marie, do you want to catch us up on developments in Ireland?
Yes, of course. Thanks, Paula. I think you're right. There was a lot of focus on the Irish Data Protection Commissioner in relation to this judgment, particularly given the amount of multinational and technology companies that have their headquarters in Ireland. And from that perspective, and also obviously given that the case originated here, I think in, let's say, the immediate aftermath after the decision, the Data Protection Commissioner here in Ireland, Helen Dixon, she welcomed the decision and a statement was issued. The 2 points that were were key from the Irish Commissioner's perspective were, number one, that the court endorsed their concern that EU citizens' data was not protected when it was transferred to the US, number one. And secondly, they endorsed their view that any transfers required equivalent protection to that are afforded to citizens within the EU. So that was the basis of the statement. There was one key sentence within that statement that caused a significant amount of concern. So when you mentioned the sharp intake of breath earlier with regards to the decision, there was a second sharp intake of breath with regards to this particular statement. And in effect, what the Data Protection Commissioner stated was that the application of standard contractual clauses, that transfer mechanism of data from the EU to the US under standard contractual clauses was questionable. So I think at an immediate, that raised immediate concerns for a lot of organisations. One thing just to bear in mind, while that is the statement that has been issued, the Commissioner has verbally given assurances and some informal guidance through various Q&As, which I think will be useful for everyone to understand as part of their, let's say, remedial action or their due diligence process, which is going to be a fundamental element of what organisations need to do.
Maria, I think, that insight is really important, because when you really dig into this, the implications of this decision are enormous, right?
Huge.
I mean, even just how the internet works, right? How do you even do the packets and this packet switching and all the way the data flow? If you follow the decision logically, that could potentially have some ramifications even there. So
Yeah.
I think you're right. On July 16th, there was a lot of that sharp intake of breath and the need to make strong statements. But then, right, it's very different for a court to strike that thing down, and then for regulators and legislators to then think about, okay, what's next? Like, how are we going to actually do this in practice? So that's really valuable insight. Thank you. Paul?
Yeah, and what's, so we had the statement obviously from the Irish Commissioner, as I mentioned earlier. Then there was a suite of different commentary that came out in the immediate aftermath from data protection authorities in a number of jurisdictions. That was relatively swiftly followed up by the European Data Protection Board, then issuing an initial guidance, in essence saying that look, it wasn't so much a case of everything was transfers were automatically no longer valid to the US, but actually reinforcing that it was incumbent really upon the relevant exporting parties to actually do the due diligence and to make an assessment in relation to the application of those surveillance laws to the particular data flows. And I think that's the important thing to think about. This is not something where you can necessarily apply whole-scale generic ways forward here. It is very much a case of you have to look at the nature of the data being transferred, to whom it's being transferred, how it's being transferred, where it's being transferred, to work through, can I still do this? But the other piece that was again reinforced in that opinion, but more still to follow, is that the EDPB basically said you can consider other mechanisms here. Can you protect the data in another way? And so a lot of attention is also being given to the degree to which techniques such as encryption might be helpful in making sure that only those that the controller, those folks that the controller wants to have access to that data, does then get access to that data. Within that period of time where we were waiting for the EDPB opinion to come out, it wasn't a huge surprise, perhaps, that we saw some perhaps slightly hawkish commentary come out of particular jurisdictions. One of the jurisdictions where I think we were all sort of looking with, and were not too surprised, Nils, was Germany.
You're really picking on me now, Paula.
Sorry.
It's your turn, my friend. It's your turn.
Oh, Michael, come on. I knew this was going to happen. So, Paula, you're right. Well, I mean, if you ask me about the views of the Data Protection Authority here in Germany, I mean, we often have this discussion, tell me which one. Tell me which one, right? I mean, we have a specific situation here in Germany, apparently. We have basically the advantage or disadvantage, whatever you want to call it, of having 17 different data protection authorities, 16 on a state level, 1 at a federal level. Together, they combine as the so-called DSK, Data Protection Conference. And their view is, in essence, Paula, what you just described on the European Data Protection Board. It's rather generic, not too much into detail. Yes, standard contractual clauses cannot be used as they are. Amendments need to be made, yes. So some options apparently for companies to navigate around this, to build up strategies. When you're a company located in Berlin and in Hamburg, situations often look different because, let's call them, there are some hardcore hardliners in the authorities here. And it wasn't a surprise basically from Berlin that there was a statement really on the day after. I mean, it looked like really they have something, or it just pushed the button, after the decision because we knew what's going to happen. And they just basically said, everyone under the supervision in Berlin has to shift over immediately the service providers from the US and other similar regions to European solutions, which of course is not something which is, from a commercial and a business perspective, something a workable solution. I mentioned the DSK, so the Combined Data Protection Authorities view, which was more general. This was issued later after the Berlin one. And very surprisingly, Paula and Michael and everyone, just recently, last week, we had a really interesting guidance coming out from Baden-Württemberg Authority, which is like Stuttgart region, where Daimler, for example, is located. And they provided a checklist, not only checklist, but also I think companies nowadays really are looking for what can we actually do now? I mean, we always hear about standard contractual clauses. We cannot use them as they are. But what can we actually do? I mean, it's all about this is what you cannot do. And don't know whether you can guess, Paula, on any changes they suggest on the standard contractual clauses. It's nice to have something. I mean, it's better than nothing. Come on.
But Nils, you bring up a great point, and I think Paul used the word geopolitics at the top of this call, right? There's rarely anything you can ever do in contract that's going to trump a law, especially a law or authority in another country, right? It almost, this is the sequel, right? We've seen Schrems I that eliminated a safe harbor, and that gave, rise to Privacy Shield. These kind of things, are not going to be solved via new contracts. They're going to have to be solved at the diplomatic and political levels to get really solved with any type of certainty until a few years from now you get Schrems III. But right at the end of the day, it's about taking a pragmatic approach where you can. And I think it's going to be easier to take pragmatic approaches in certain jurisdictions than in others. Would you agree with that, Nils, even within Germany?
No, absolutely, I agree. And I think also looking at the Baden-Württemberg statement, they appreciate also pragmatic solutions to some extent. I mean, they appreciate and they want companies to consider what are really our essential data flows to third countries. Can we substitute them? What is the effort in substituting them? They know that it's going to cost money, and they know it's not a one-time exercise you do today and you're done tomorrow. I mean, that's appreciated, but I think it's also for companies to not only do the due diligence in what are the laws in the third countries, but the authorities, they really want you to look at your digital strategy. I think, Michael, you mentioned it earlier. I mean, that's a good term, actually. what is the digital strategy behind it? And speaking of that, I think that's my opinion, my personal opinion, is when it comes to intragroup data flows, and we leave aside now the sub-processes that may sit on these intragroup data flows as well with their technical solutions. But I think intragroup data flows may be something which may be more recognized and more be considered by authorities as being like really essential, where the parent company is located in the United States. And with some additional measures, with some additional contractual clauses, this may be a solution coming up for intragroup data transfers. It's up to see, but I think authorities know that it's a hard time.
Yeah, and for purposes of the United States, for CLE, in fact, the code is digital strategy, excuse me. So thanks for bringing that up again, Nils. So for those who want CLE credit, it is digital strategy. Should we turn to Robert and hear some of the views out of the Netherlands?
Yeah, sure. Thanks, Michael. And yeah, well, the Dutch Data Protection Authority is quite expectant this far. Sometimes we see they do have a very strong opinion on, for example, COVID-related topics like temperaturing and contact tracing apps. But yeah, here they have merely indicated that this is the decision, and they are just referring to the European Data Protection Board for further guidance to be issued in due time. But I think it shouldn't be neglected that they actually do have a strong voice within the European Data Protection Board. And I'm sure they will have a strong opinion on this as well. And also, and this was stated by its president, Aleid Wolfse, known for its kind of harsh statements in the past. He indicated in several radio interviews that they will not remain hesitant to enforce where appropriate. And this was, I'm not joking in this respect, accompanied with this already classic statement that they have never been overturned or overruled by any court or judge in the Netherlands. So yeah, this is what we have to deal with here in the Netherlands. But the fact is that, yeah, essentially when a company violates the GDPR in terms of having an insufficient mechanism in place or having insufficient measures in place, the Dutch DPA can impose a fine of generally 525,000 euros according to its latest fining policy. And also for this reason, it's strongly advisable not to, as we just talked about, not to adopt a wait and see attitude, but to really investigate the appropriateness of the level of protection in the relevant countries by yourself. Identify your data flows, identify your vendors, identify your providers at risk, and do your due diligence homework, basically. And another thing I would like to address, although a bit off topic, but nevertheless relevant, and I will keep it short, is that there are emerging several consumer groups supported by activists and newly incorporated privacy foundations, even financially supported by litigation funders such as hedge funds, to bring class action lawsuits against tech giants and platforms for data protection law violations. And this all is made possible by a new Dutch law in force since last January called the Act on Collective Damages in Class Actions. And I think it's not strange to have some mixed feelings about mass claims about privacy that are made possible by no cure no pay basis by litigation financiers and hedge funds for commercial motives. I mean, we even see colleagues, some fellow Dutch privacy experts of name who are now committing themselves to this. But coming back to the discussion of ours today, you can already predict that the lack of an appropriate mechanism for cross-border data flows, for cross-border data transfers without any sufficient due diligence and consequent remedial measures would fit perfectly into their story. And actually my point is, and I think that these developments should not be taken lightly, also in terms of liability and damages for companies. And therefore, like you, I would like to stress the need of a solid data strategy, digital strategy, and a frequent due diligence and cross-border data flow analysis. And that's what we're talking about today. But yeah, you will take us further on that, Paula and Michael.
No, Robert, those are really good points. And I love how you sort of advise against taking a wait and see approach, because I think a lot of companies are doing it. And there's some logic to it, right? Because even as Marie was talking about, even the regulatory approaches are changing, sometimes subtly, sometimes more dramatically. But the trend lines are clear, right? This is going in a certain direction and it's not going to stop. It may go a little bit slower, it may get a little bit more pragmatic, but right, and Nils, to your point, I think the quote that came out of Germany, the Berlin, right after was the age of European data independence is now, right? So it's a very sort of, this is my data approach, right? And you're seeing that crop up in many jurisdictions in many countries around the world. So incorporating into your digital strategy, at least the ability to localize data a little bit is probably where things are going, right? I think Nils talked, and Paula spoke about deciding between your must-have data flows and your nice-to-have data flows. Can you, mitigate your risk by doing some degree of localization, right? Obviously that's going to be an operational decision informed by legal risk, and it may vary your risk by jurisdiction, but these are the thoughts that you have to proactively think about, not take that wait and see approach, because if you identify a trend, if you anticipate where things are going, you're not going to suddenly be on the back foot every time a decision comes out, a regulatory action comes out, or as we're seeing also class actions, right? This is yet another gift to all of you from the United States, not only surveillance authorities that cause of Schrems II, but the gift of class actions, right? This is now hit European shores, and it increases the cost of non-compliance dramatically. Well, I don't think we've heard too much on the ICO's views. So now we can.
You caught me. You caught me. Okay, so briefly on that then, because I think this comes at a pretty interesting time for the UK. We are, outside of the EU, soon to be outside of the customs union. So in essence, it's a time where we are looking to do a deal so that we can continue on a trade basis. And it's pretty clear that data is one of those topics that is a key negotiation point, and it's been made very clear that the UK would like to have an adequacy decision. Thank you very much. We've adopted the European legislation. We have thus far been within the European membership, able to receive and transfer lawfully, and would like to continue to do so. But as a matter of law, we are no longer within the European Union, and therefore we are a third country. So from assuming there is no adequacy decision from at the point at which we leave the transitional arrangement, then ultimately we will be a third country. Therefore, transfers from Europe to the UK will need to be addressed in a similar manner. It's in essence, it's a transfer to a jurisdiction that doesn't have an adequacy decision. And so adoption of standard contractual clauses is likely to be the go-to mechanism. So in essence, you're going to see a lot of assessments being made in relation to the UK and indeed the UK surveillance laws and the way that they operate and the way that our data protection laws operate in conjunction with those to afford protection. So we are going to see that. There's also, of course, some degree of concern that having seen, in essence, Privacy Shield swept away again, that will have something of a chilling effect on the willingness to actually give an adequacy decision to the UK, notwithstanding ongoing political and economic debate at this time. So it's a critical time, and so very closely observed. And alongside that, of course, we then saw in the initial aftermath of the ICO saying, okay, pause, if you have Privacy Shield, kind of wait and we'll come back to you. They've now adopted the commentary of the EDPB and fallen in line with that, but all eyes are on what will happen next here. And there does seem to be an increased amount of commentary about the degree to which the UK government in particular will pursue making changes which will facilitate trade data transfers, not just with the US, but indeed with multiple other jurisdictions to facilitate trade going forward. So it's something to keep in mind over the coming months in that respect, I think. So mindful that we've spoken about different jurisdictional perspectives in relation to this. Shall we move on to the next slide? Let's start talking about in more detail about really how to really address this at a practical level. What are you doing? It starts really with assessment, understanding just what transfers do you actually do. Now, if you've already been working on your GDPR compliance programs, then a go-to place for that is to go and look at your records of processing. You may well have a lot of this documented already, so the heavy lifting done. But pulling that information to understand what are we doing, where's it going, who is it going to, bearing in mind this point about you're not just looking at an immediate perhaps an affiliate transfer, but also what technology are you using to facilitate that particular transfer. So you're wanting to understand onward transfers, you're wanting to understand sub-processors. In practice, what we're seeing is also a number of due diligence questionnaires emerging. And I think that's quite an interesting topic in of itself as to what questions should you be asking, and then will you understand the answers that come back? Because I think we've certainly seen some already where in essence questions have been asked, does Pfizer apply? And the answer has come back saying, no, it doesn't, when actually Michael and I have, of course, are you quite sure about that? So Michael, your views on, you've been seeing some of those questionnaires.
Yeah, look, they're very important, right? The EDPB said you must take supplementary measures. That includes a degree of due diligence. So yeah, you can send out a questionnaire. I mean, you can start by assessing whether FISA applies to you as either a controller or a processor. And then as you go through each data stream, and you can look at your record of processing activity, or you can look at some of the work you've done for the California Consumer Privacy Act to identify your data flows and say, okay, this goes through this processor. I need to check if this processor is going to have some exposure to FISA. And even if they don't, how are they protecting the data from passive collection of the type we were talking about under EO 12333 when it transits from the EU to the United States, right? And look, as Paula mentioned earlier, it's not just about the United States. That's the focus of the case, right? We got an interesting question from, how is this going to affect transfers to Hong Kong? You're going to have to look at, surveillance authorities that may impact there, right? For each jurisdiction without an adequacy decision by the European Union, you're going to have to assess the degree to which those surveillance laws are going to attach to that particular data stream, as well as to you writ large. And that's really important.
And I think there's a degree of risk assessment and prioritization, I think, that practically speaking, it is being undertaken to look at the biggest density of data, the nature of that particular data, to what degree is that really going to be of huge interest from a FISA order perspective, as well as looking at jurisdictionally where those transfers are going to. Is it something that might have additional protection because it's within the remit of an intergroup arrangement, as Nils was referring to, as opposed to those that are going completely outside of the relevant group? So a degree of prioritization is, I think, really important practically to get through this.
I think practically is exactly how to answer these questions, right? You've got to think about when you're doing this due diligence is what, if challenged by a regulator, what do I want to tell that regulator? We want to be able to say, hey, we're fine transferring this to the United States or wherever because FISA doesn't apply, and we've used end-to-end encryption, right? Whatever that may be. You want to have a good story to tell so that you're reasonable, that you're pragmatic, right? And then, of course, consult Nils, consult Robert, consult Marie, consult Paul to say, is this going to fly for those kind of regulators, right? Or should we phrase it this way? Or really, what's your risk appetite? Because if it's really low, then maybe you don't do this in jurisdiction X, but you try it in jurisdiction Y. So having those conversations are really important. Marie, I know you've got some good insights and some informal guidance from the DPC. Is there anything you want to share on that or in general?
Yeah, so I think actually the statement you made there with regards to that due diligence process and that assessment that needs to be undertaken, that was one of the things that, as part of the informal guidance issued by the Data Protection Commissioner, she did, as part of a Q&A session, mention that as an immediate step, it's important for organisations to start the due diligence process. And really, at the end of the day, this forms the basis of the basic accountability principle. So it's being able to demonstrate as an organisation that you've taken the steps to assess, number one, that you understand if there are risks. If there are risks, what mitigation factors will you include in order to safeguard those transfers? And then ultimately make a decision based on that assessment. She did go on to say that in the event that there are risks highlighted that you can't in effect mitigate, that the transfer should cease. I think in reality, and that's back to the point that we've all been discussing, we have to be practical here, and we can't shut down the internet. But I think what we can do as organizations is essentially put in place those safeguards and seek to mitigate those risks that are ultimately identified. And in reality, these obligations sit side by side with our accountability obligations set out in the GDPR in reality. So that's an important point. Another piece that the Data Protection Commissioner has indicated, she has indicated that in reality, part of the rationale for their immediate statement and the statement with regards to the standard contractual clauses being questionable was ultimately to do with the fact that there was an inherent fear that the immediate steps would be taken, that those 5,300 companies that Paula mentioned at the outset would immediately just literally transfer and sign up to standard contractual clauses without that immediate assessment. So she indicated that, like the case did, while the standard contractual clauses are valid, she wouldn't necessarily be immediately pushing companies to that solution without undertaking that assessment. So I think the assessment is going to be fundamental. Identifying the risks is going to be key. And then when you have identified those risks, put in place those safeguards that can mitigate as much as possible, or as much as practicable, really, those risks in reality. And I think, Michael, it's back to the encryption point. It's back to identify the risks in the first instance, because if you don't do that, how can you mitigate against them?
And I think what we're also seeing is, one of the things we are expecting there to be ultimately some further guidance that emerges at the EDPB level. We are also expecting there to be new versions of the standard contractual clauses emerging. We know they were deliberately held back pending the outcome of this decision. So one might expect that they will come out with some further enhancements. As Neil mentioned earlier, we've had some nods towards that already from one particular state regulator. But what we're starting to see, for example, are some confirmations around that either they're not subject to that particular regulation, or that in essence that they will, if they receive such orders, that ultimately that steps will be taken to defend against them. That notice will be given where that is permissible. Where it's not, then you'll have the language already that's in the standard contractual clauses about giving notice that the clauses can no longer be complied with. So there's a number of different mechanisms that are in there talking about enhancement of notices given to individuals where transfers are to be given. So some movements in around the contractual space around that. We're also, there was a statement in relation to Privacy Shield that the Commission and the US authorities are indeed engaging in further dialogue. So, perhaps we will see, Mark III emerge as a solution too.
Yeah, and right. I think, Paula, you make some great points. There's a lot that we can do via questionnaires. There's some things that we can do via, contracts outside of the standard contractual clauses, including, an obligation on, especially those that FISA doesn't apply to say, if somebody does try to serve me with a FISA order, I will vigorously object, or I'll let you know if I get one. To the extent I can, right? There's some limitations, obviously, on doing that for surveillance requests, but still, you can do things practically to better position yourself and to just try to continue to do business. And also, while there is little to, if any, discretion in the interpretation of the judgment among European and UK regulators, there is some discretion in enforcement, right? So again, you want to take that nuanced approach. And you also have to really think by data stream, precisely as you've heard before, right? Because if you're transferring employee data, for example, that might have a different risk calculus because, and I'll turn to my colleagues here, but my understanding is, privacy regulators are duty bound to investigate any complaint. So if you upset one of your employees, which is particularly easy to do in the age of COVID, right? With all the uncertainty going on now, they make a complaint, boom, right? You're going to get investigated. So you actually also want to factor that in, right? Sure, there are certain big companies that maybe regulators will go out first, but then they have to investigate complaints. Did I get that right, Paula? Or, no?
Indeed, that is the nature, that they have some constraints over their ability to deal with this, and ultimately that's one of the reasons why there wasn't a grace period in the wake of this particular case, because they have this duty to investigate. They can choose to a degree where to allocate the resources, but they do need to respond typically to complaints and address some of those. Although again, we've had criticisms of the number of cases that actually do get addressed for pretty resource constrained regulators at this time.
And that goes to Robert too, which is why you're seeing more of it go into the courts. Right?
Yeah, I think that's right.
Yep.
So
that's right.
I think here it's a question of trying to take some action, so as we've heard, so that you actually do have a good ability, recognizing that this is all under the accountability requirement to be able to evidence the process, evidence that you've looked at this, that you have actually done the due diligence. So that sits alongside the paperwork, as well as ultimately some of the practical steps like encryption that you will be taking. And this also circles back ultimately, as we said at that outset, to this strategy, because there is a point here that this is a recurring theme, and that one of the critical things to look at here is whether this theme of localization, which is emerging, is something that needs to be cause a revisiting of approach adopted. That can there be movements made so that some of this data doesn't ultimately transfer outside of the European or the jurisdiction concerned, that it stays there? Because I think there is a tendency, or has been perhaps as we've moved towards a greater digitalization, consolidation of systems, also for access to be granted, and perhaps more freely in some circumstances than it needed to be. So I think we will also see a trend of just maybe a little bit of retrenchment of that, a little bit of pause to work out, is that still appropriate, so that you are only operating on the basis of transfer where it really needs to happen, as opposed to it being nice to have.
Well, thank you. I know we're 2 or 3 minutes over. I hope everyone found this useful. There are some additional resources that are up there on your slides, and feel free to contact, of course, any one of us if you have any further questions or would like any further information. And with that, thank you, Paula, Marie, Nils, and Robert, and to obviously everyone who joined us. Take care.
Thank you.
Thank you.
Bye-bye.
Thank you.
Great evening.